And the Supreme Court's hearing arguments in a landmark case over transgender athletes in female sports. The court's hearing arguments in a pair of cases from Idaho and West Virginia where federal courts have blocked state laws prohibiting trans girls from playing on girls' teams. The Trump administration and more than half the states in the country have tried to ban trans athletes from competition. Now the Supreme Court will decide whether those efforts are unconstitutional. ABC News legal contributor and Hofstra law professor James Samples here with more on those arguments so far. Hi, James. So far, Idaho and the Trump administration have argued states should be allowed to separate their sports teams on the basis of biological sex. Now the justices are hearing from the lawyer for the Idaho student who challenged the state law there. What stands out to you so far about the way these arguments are being made and the questions some of these justices are making?
Diane, it's really good to be with you. And what stands out so far is that an argument scheduled for 1 hour and then another argument scheduled for 1 hour has already taken over 2 hours. And just moments ago, literally in the last 20 to 30 seconds, the first of the cases, the one out of Idaho, just concluded. They're taking a brief break, sort of shuffling in the next batch of attorneys. The justices are perhaps taking a restroom break, and then they're about to start right back up again. And that speaks to just how prominent this issue has become. It's an issue that has sort of crossed up traditional partisan leanings in a lot of respects. It had a major role to play in the 2024 presidential race, and now you're seeing this culture hot button issue litigated before this U.S. Supreme Court. The two plaintiffs in these cases argue that they are individuals who were born biologically male at birth, but who have taken a combination of hormone suppressants and other treatments and who want to be able to be allowed to compete on girls' and women's sports teams. Idaho and West Virginia are two of the 27 states around the country, as you noted in that map, that have bans on this. This case will likely be decided, based on the oral argument so far, in favor of the states that have the ban. However, there's some question as to whether or not a ruling that favors the bans in Idaho and West Virginia would necessarily mean that other states are allowed to have a ban or are effectively required to have a ban.
And James, I want to play a moment from an exchange earlier between Justice Sonia Sotomayor and the Justice Department lawyer. Let's listen.
What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say...
When the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable.
James, what do you think Justice Sotomayor is getting at there when she's asking about the percentage that meets the bar to qualify someone as a subclass?
Well, Diane, at the risk of alienating our viewers and getting really deep into the weeds, this is a very technical distinction between what's known as a facial challenge to a law and an as-applied challenge to a law. And to put that in simple terms, a facial challenge to a law would say this law is unconstitutional, full stop. An as-applied challenge to a law is a challenge where the party might say that this law may be constitutional as applied in some contexts, but it is unconstitutional to apply it to me without an exception. And so what you're hearing here, and you heard this from a number of the justices who traditionally lean to the left of the court, is the idea that the plaintiffs here are not seeking to declare this law, these bans, unconstitutional writ large. They're saying that applying them to their particularized circumstances, very context specific, what they are seeking is not to overturn the ban overall, but rather that they are seeking an exception. And the Trump administration lawyer whom you heard from there is saying if only 1% of the athletes in the country are transgender athletes to whom these bans would apply, then what is not necessary is for the law to be perfect, even if it sweeps in a few people that make it sort of imperfect in application.
All right, James Sample, always great to have your analysis. Thank you.